See, there are many ways of answering that. So let me start with the mother, Shamima Kauser, who I represent legally. According to Shamima Kauser, Ishrat Jahan is her daughter, and Shamima's husband used to be a developer builder in Mumbai, which is in the suburbs of Thane in Maharashtra, a largely predominantly Muslim dominated area. And he ran into bad business, which led to him falling seriously ill, and he died in 2002, leaving Shamima Kauser with daughters and sons. Shamima Kauser is not very literate, had never earned money. She suddenly had the responsibility of a lot of children to bring up. Ishrat is her second eldest daughter, and Ishrat was good in academics, good in school studies, and therefore she started finding ways of supporting the family. All the girls started doing some stitching, embroidery, and Ishrat started taking tuitions. In 2004, June, when Ishrat was killed, she was studying BSc in first year in Guru Nanak Khalsa College, and alongside was taking tuitions. Javed used to work as an electrician and over there. So through them, somebody said, oh, it's the same Javed who was known to her father. He is looking for a woman to work with him. So why doesn't she take up employment? For 3,500 rupees, she took up employment with him. Now let us see what does the charge sheet, which is filed pursuant to the SIT, monitored in investigation, monitored by the Gujarat Division Bench, High Court, as well as the CBI. Investigation. The CBI filed a charge sheet. That charge sheet actually says very categorically who is Ishrat Jahan. It's written in the charge sheet, and so I will just read out for you from there itself. So I'm reading out to you from the charge sheet dated 3rd July 2013, which has been filed against 7 very top senior police officers of Gujarat state and 4 IB officials for the murder of Ishrat Jahan and 3 others. There is a subheading there given, antecedents of the deceased. These aspects would be fully confirmed only after custodial interrogation of the persons involved. And then it goes on to says, however, the following facts are notable at this stage. Ishrat Jahan, 19 years old and student of second year BSc, when she died, had no criminal record. She had met Javed alias Pranesh for the first time on 1st May 2004. She had travelled with Javed to Lucknow and Ibrahimpur district Faizabad in UP and twice visited Ahmedabad with Javed. She may have understood that Javed was engaged in illegal activities involving smuggling and counterfeit currency. Statement of Rashid, he is the one who introduces them. Statement of Rashid also indicates that she had knowledge about Javed's illegal activities before she joined him. However, there is no evidence to indicate that she had any terrorist links. Certain news reports, and then they talk about other things. So very categorically, the charge sheet actually corroborates everything that Shamima Kauser has said, and that is really how this matter has begun. It's very important for me to say over here that in June 2004, after Ishrat was murdered, Shamima Kauser herself went and filed the writ petition in Ahmedabad High Court in August 2004. The politicization of the case, different political parties wanting to make much of it, all that has happened much later down the line. In August 2004, Shamima Kauser goes and files a writ petition because she is convinced, and she said, my daughter was not a terrorist. We had run into very hard times. We were not accustomed to being so poor. We didn't know how to deal with it. She stepped up and took responsibility for the whole family. I cannot live with with everybody pronouncing my daughter as a terrorist. Therefore, she went and filed a writ petition saying, I want an investigation into this. It had nothing to do with any political party at all whatsoever, and in fact her claim is corroborated by what is mentioned in the charge sheet after much investigation. And we also know that the magistrate SP Tamang in his report says that she was an innocent college-going 19-year-old girl who was murdered, and then because she had been murdered, in order to build an entire and prop up this theory of an encounter, they had to label her as a terrorist. Otherwise, how do you justify the murder of a woman who has nothing to do with any terror activities? In any case in law, you cannot even kill a terrorist who is in your custody. Well, interestingly, this case has been at a standstill now for very long. In the charge sheet that was filed in July 2013 against 7 police officials of Gujarat, and then a supplementary charge sheet filed in February 2014 against 4 IB officials, including a senior IB officer. All these have been filed way back now, 2 years at least, in the Mirzapur Special CBI Court of Ahmedabad in Gujarat. Thereafter, nothing whatsoever is happening in this case. The investigating and the prosecuting agency is the CBI. We are told that CBI works very independently, and so the question that Shamima Kauser has, and as a lawyer for Shamima I have, is once a charge sheet is filed, why does this case not progress? Let me just reiterate here that actually this question is irrelevant and redundant to the criminal case that refuses to move ahead against the Gujarat IPS officers as well as the IB men. Her antecedents have no relevance because she had been taken into custody, she was illegally detained, and she was murdered in cold blood. So who she was is not relevant to the criminal case. It is obviously relevant to the political situation that we are in. Now here what is, why is it that the BJP wants everybody only to focus on whether the people who were killed were terrorists or not? It's not only because they have an understanding and a vision of the country which is contrary to the constitution or contrary to the rule of law, and they really want to change the rule of law in order to decide who should be executed, not executed, given a trial, not given a trial. Of course, we are seeing much of that is happening even as we speak in many spheres. But there is a specific reason why this particular encounter troubles them and bothers them. After all, the Sohrabuddin encounter happened. It went through the process. It is very peculiar and interesting how Mr. Amit Shah gets discharged and the CBI, which is so independent now under the Modi government, does not even file an appeal against the discharge. Why does this case nag the BJP, and why do they want to constantly distract us into this Lashkar-e-Tayyaba story is also available from the charge sheet, and everything that I am telling you is only from the record, nothing that is part of my own imagination at all. So this charge sheet, which as I told you was filed in July 2013 before the Gujarat CBI court, naming many police officers, has the statement of one Mr. D.H. Goswami. Mr. D.H. Goswami is now a retired DYSP of the police. And he makes a statement, and the statement is recorded before a metropolitan magistrate. So it's not a statement to the police, you can't allege torture, etc. And he says that he was there when these people had been taken into custody. And I will just read out to you the relevant portion of what DYSP Goswami says. He says, on 13th of June, 2004, I along with GL Singhal went to Khodiar farm by private vehicle. I had prepared draft bandobast for Rath Yatra. When we reached at Khodiar farm, DG Vanjara, who is also one of the accused, and one Rajinder Kumar. Rajinder Kumar is the IB officer who has been named in the supplementary charge sheet, were present there. So he says on 13th June, he went with GL Singhal, he met DG Vanjara and Rajinder Kumar at Khodiar farms. I handed over the file to GL Singhal and came out. I waited 2 hours and returned to Crime Branch office at Gaikwad Haveli. In the evening around 7:30 p.m. to 8:30 p.m., I had gone with GL Singhal to bungalow number 15, office of Joint CP. I saw that DG Vanjara, Rajinder Kumar and one PP Pandey, Joint Commissioner of Police, were present there. they were talking about a Lashkar-e-Tayyaba operation. That time, Rajinder Kumar told DG Vanjara, talk to Chief Minister about it. Shri Vanjara told that he would talk to Safed Dadi and Kali Dadi, and thereafter I came out of chamber of Shri VG Vanjara. Shri Vanjara. PP Pandey also came out. After some time, GL Singhal also came out of the chamber and returned to the Gaikwad Haveli office. On 14th June, the next day, afternoon, now this is the day prior to the 15th June murder. On 14th June afternoon, I along with GL Singhal went to the chamber of DG Vanjara in the Shahbag office. Vanjara handed over one written complaint to GL Singhal. There was plan to kill some persons of Lashkar-e-Tayyaba who intend to kill Chief Minister. GL Singhal was disagreed regarding the draft complaint as there was something to do about the girl Ishrat. But Vanjara was adamant. Shri Vanjara also told that he approved from Chief Minister and Minister of Home. Thereafter, I and Shri GL Singhal came to Gaikwad Haveli. Now, the complaint of the FIR that was subsequent to the fake encounter lodge had already been prepared in advance, because obviously it was all a staged killing. In that it was mentioned that they are also killing Ishrat, who was a Lashkar-e-Tayyaba operative. GL Singhal disagreed because he knew, as did everybody else, that she had nothing to do with the Lashkar, and obviously he was of the opinion that they should let that girl go. She may have been at the wrong, caught by them at the wrong time with the wrong people, but let her go. He says, I have received approval of this encounter, including the killing of Ishrat Jahan, from the Chief Minister and the Minister of Home. We are obviously talking about the state of Gujarat in 2004. And subsequent to that, the encounter does take place. Now, this is a 164 statement which has very high evidentiary value, which stands in the charge sheet even today. And that is the reason why this encounter case cannot begin regardless of the autonomy that the CBI enjoys today, and why there is such a concerted effort to constantly talk about Lashkar-e-Tayyaba and tell us, look, it doesn't matter that we killed them, it was for the good of the nation. But since all record speaks to the contrary, they are not able to do anything about it. In response to the writ petitions filed by Shamima Kauser, the mother of Ishrat Jahan, and Gopinath Pillai, the father of Javed, the Union of India, through its Under Secretary, Mr. RVS Mani, filed an affidavit in August 2009. Now, this affidavit, what does it say is very important, because much has been made of this affidavit over the years without anybody actually reading the contents of the affidavit. It's become almost like a football between political parties. What does this affidavit say insofar as it pertains to whether Ishrat was an LET operative or not? We have to, in order to understand this killing, let us look at the background and linkages of Javed. Javed, who actually was originally, his original name was Pranesh Kumar Pillai. He was a Hindu from Kerala. He converted to Javed in order to marry a Muslim woman called Sajida. And there was nothing more dubious than love. That was the reason for his conversion. And he adopted the name Javed Ghulam Muhammad Sheikh. So who is Javed is then detailed in this. And they come to a couple of conclusions, saying that what is suspicious about Javed is that, he's a rowdy character who has some criminal cases registered against him. He's probably been doing some illegal activities, and that he has procured a passport in a Hindu name in his Kerala address, although he's no longer residing there. So they come to the conclusion on the basis of this and the fact that he has worked in Dubai, he has visited Oman. All these are taken as suspicious circumstances, and they say these facts point towards Javed being a person with a criminal bent of mind and working for some ulterior motive etc. Now, I'm saying let us take it for granted that Javed is probably a criminal. He's involved in some crime, maybe he's involved in counterfeit currency, I don't know. That is for them to investigate. Whether that in itself leads to any further conclusion than the fact that he, like about a few million other Indian men, are engaged in crime. And then they say he had gone to Dubai and worked for several years, and he undertook a visit to Oman 2 months before the incident happened. Then it comes to, this is all regarding Javed, it has nothing to do with Ishrat Jahan. Let us come to Ishrat, which is the subject of interest of every political party here. What does this affidavit say? The affidavit says that the Times of India, the Hindu, the Indian Express published a news item on July 15, 2004, which is roughly a month, exactly a month after the killing of these 4 people. And these newspapers said on July 15, 2004 that Lahore-based Ghazwa Times, the mouthpiece of Lashkar-e-Tayyaba, had said, and then they quote, "The veil of Ishrat Jahan, a woman activist of LET, was removed by Indian police and her body was kept with other mujahideens on the ground. Ishrat was with her husband sitting on the front seat of the car." This is reported from the newspapers, who in turn have taken it from Ghazwa Times, which is a mouthpiece of Lashkar-e-Tayyaba. That is the basis of the information. It is not an intelligence input. This is not something the Home Ministry has received input from the IB at all about. Let us go further down the affidavit. And then he says that, how could she not have known that this man was doing dubious activities? That really is neither here nor there. It further goes on to say that on May 2nd, 2007, Jamaat-ud-Dawa, another mouthpiece of Lashkar-e-Tayyaba, published a news item, an apology to Ishrat Jahan family. Just a few days before the petition was filed by Gopinath Pillai, this time it says that several Indian newspapers, now this is also reported in Indian newspapers, Business Standard had described this. So first they say she was, and then they publish an apology saying, we've got the information wrong, she had nothing to do with Lashkar. This was also reported by Indian newspapers. And what does Business Standard carried an article saying, an intriguing apology from LET. It says, and so that is the basis on which they say that this apology, first they claimed her as an LET operative. They get to know this from Indian newspapers, the Home Ministry, and then they say it was, they said they apologized, and this again they hear from Indian newspapers. And on that basis, the Home Ministry's Under Secretary in the affidavit says, it is clear from the above that Ishrat was actively associated with LET, and apology by LET mouthpiece is only tactical to discredit Indian security agencies and police and aimed at misleading the court. So if it is my belief that my years of work in Indian courts, that Indian courts are not necessarily relying upon mouthpieces of Lashkar-e-Tayyaba to decide criminal cases. So as far as the facts are concerned, there is still no evidence or information whatsoever that she had any linkage with the Lashkar-e-Tayyaba. In fact, there is much evidence, and every probe, whether a magisterial inquiry, an SIT probe, a CBI investigation, each one of them reaches the same unanimous conclusion: she had nothing to do with any terror group and had no terrorist links. That is what is established. Now, this is what this August 2009 affidavit says. And much is made of it that, look, at that time the Congress government had agreed that she was Lashkar-e-Tayyaba. As far as I am concerned, this is not an affidavit on which any reliance can be placed. You are telling me you read something in a newspaper, and therefore you think because the newspaper says so, and the newspaper says so because Lashkar-e-Tayyaba says so, therefore it must be. It's not an affidavit on which any credence can be placed. But yes, you can make a political drama out of it. So what is the political drama about? The political drama is that first the central government agreed she was Lashkar-e-Tayyaba. Then they gave a second affidavit. The second affidavit comes in September, within a month, by the same RVS Mani. who again he's still working as Under Secretary Internal Security. Actually, on reading these affidavits, as a citizen of India, forget being the lawyer, I am worried about the country's internal security, because clearly it's not being handled with any level of seriousness either then or now. What does he say in this affidavit? He says that the allegations that have been made, we are only responding to on the basis of the inputs. Those are general inputs which are always given. That is something that is well known, and these intelligence inputs are then shared with the state government. The state government has to look into it. The part that becomes the source of a lot of controversy is, they say that para 8 which I read out to you, which is basing itself upon the news items, says it does not constitute intelligence inputs, and the inference drawn in relation thereto have been needlessly misinterpreted. This is written in the affidavit. Now, even if this subsequent affidavit had not been filed, any lawyer, any judge reading this affidavit would understand that this is not an intelligence input. By way of explanation, because the Gujarat government at that time used this affidavit to create a complete media frenzy and hysteria, saying, oh, now see, it stands confirmed that Ishrat Jahan was an LET operative, because it has been said by the central government. But the central government never said it had any information to that effect, and it clarifies that in its subsequent affidavit. So this second affidavit actually doesn't add or detract anything. The first affidavit did not give you any intelligence inputs. The second affidavit, because there was a media frenzy created and a deliberate misinterpretation done of what was put out, as though some heavy duty intelligence input had come our way, they said, look, we don't know. This is for the court to decide. And as I've been saying repeatedly, for Ishrat there is no evidence. For Javed, there is evidence that he was a rowdy character or was indulging in criminal activities. There are two other men on whom there seems to be evidence that they were LET operatives or some sleeper cell of the LET. Even a sleeper cell of the LET, once taken into your custody and detained by you, you cannot kill them. That is why there is a murder case against these police officers and IB men, which is the crux of the criminal matter. So why is all this being constantly brought up? Now, before I go to that, I just want to show you one more thing with reference to these affidavits. There is a police officer by the name of GL Singhal, who was in the anti-terror squad of Gujarat. GL Singhal shot to fame on many occasions. One of them being that he is an accused in the Ishrat Jahan murder case. The second being that he is specifically named in the Supreme Court judgment as being the senior police officer responsible for falsely implicating 6 men in the Akshardham bomb case, as well as torturing them. It is detailed, the way he has tortured them is detailed in the Supreme Court judgment. But the reason why GL Singhal is well known to people in this country is because he is the same police officer who did the sting operation in the Snoopgate case, and it is his audio tape. So GL Singhal is clearly a very, very a police officer of multiple talents. GL Singhal's one passion clearly appears to be doing sting operations. GL Singhal knew that his name would eventually, at the end of the investigation in the Ishrat Jahan case, come to the fore. So what does he do? He starts doing sting operations. He does a sting operation even on this affidavit, of which a lot is being made. How do we know this? This affidavit this sting operation comes out and is actually part of the charge sheet record. If anybody, that is the reason why that case does not move forward, is that there is so much credit to you, the sting operation, the audio sting operation done by GL Singhal, who is currently an accused in this case. Of course, for reasons best known to the wisdom of Gujarat government, he has been reinstated in a very senior position, even as he faces a quadruple murder charge. So GL Singhal is talking to the Additional Director General of Police of Gujarat, Mr. P.P. Pandey. Singhal says, Sir, namaskar. PP Pandey says, are you in a meeting? Singhal says, yes sir, now I have come out. PP Pandey says, that order for Abhichandani is done? GL Singhal replies, Ji sir. PP Pandey says, tomorrow someone is coming. Under Secretary from Delhi for signing affidavit. RVS Mani is an Under Secretary from Delhi. GL Singhal says, right sir, right sir. PP Pandey says, tell Abhichandani, if he does properly, we may try to make him High Court judge. GL Singhal says, right sir, will explain. Ji sir, I will explain him. I have understood. Who is Abhichandani? Mr. Abhichandani is the advocate for RVS Mani, through whom the affidavit of the Under Secretary is filed before Gujarat High Court. And here is the DGP telling Singhal, make sure that Abhichandani knows what we want in the affidavit, and a very he's promised the position of a Gujarat High Court judge. It is actually scandalous for many reasons how a Director General of Police is determining who will be a judge of the Gujarat High Court. And then you of course do see the affidavit as it comes on record. So the affidavit, of which much is being made, there is A, nothing in the affidavit. B, there is a very clear evidence available in an audio sting operation, which is available on record, provided by GL Singhal himself to the CBI, showing you how this affidavit comes about. So much for the affidavit that is repeatedly thrown up, and a lot of noise is made over it to show that the Congress knew that she was an LET operative, and that the Congress is now playing around with national security issues, which is really far from the truth. And the point that I will keep on reinforcing, why does the BJP want to distract us into the Lashkar-e-Tayyaba issue? If the law is very clear, whether I'm a terrorist, whether I'm a smuggler, whether I'm a rapist, whether I'm an anti-national, you cannot take me into custody, hold me illegally, kill me, and then say it's a crossfire between us and it's a fake encounter. After all, Ajmal Kasab was arrested. He was known to have shot many people dead. There is no evidence even by them that these people fired a single shot, and yet we gave him a full trial, and there was a judicial process through which he was subjected. Now clearly the police officers, particularly Rajinder Kumar, who is also named, are getting anxious that they are still accused in a murder case, which certainly can't be seen as a small thing even under the present regime. Now let me show you first what Mr. Headley says. Let us remember that Mr. Headley, David Headley, a double agent who has sought pardon because he has agreed to tell everything, and a man that I would imagine every Indian would want to have nothing to do with, as somebody who has masterminded one of the worst terror attacks in which we lost a lot of lives. I don't know why suddenly we are told that every word dropping from the mouth of David Headley, the mastermind of 26/11, should be something that we should abide by. I thought he would be someone we see as the enemy of the Indian people. Now let us see what David Headley says. David Headley, we must remember, is giving evidence as a witness, as an approver. In a case where he himself is an accused, he's now become an approver. The evidence of an approver is in law an inherently weak piece of evidence and must be corroborated in all material particulars. So David Headley is saying so. until and unless corroborated in material particulars, even in law, can have no bearing. What does he actually say? He is also giving evidence in the 2611 trial. It has nothing to do with the Ishrat Jahan case. He is supposed to be giving evidence against Abu Jundal. It would be interesting to actually go through his voluminous deposition to see what has he said against Abu Jundal at all. Why were the questions pertaining to Ishrat and the 2004 encounter even posed to him in the course of this trial is a question that we need to ask. In a trial, you can only ask those questions to a witness which are relevant to the issues in the trial. Now, how the court allowed that to happen, and why did Mr. Ujjwal Nikam, the special public prosecutor, now much decorated by a Padma Bhushan or some such award, needs to be asked by people. Because we cannot make mockery of our national security as well as our judicial process for certain vested interests. What does he say on 11th February 2016? I'll just read out these questions to you. The public prosecutor, Mr. Nikam, asks David Headley, this is obviously happening through video conferencing, there is a women's wing in the LET. It's a question. David Headley says yes. Prosecutor says, who is the head? Headley says, the mother of Abu Ayman. The prosecutor next asks him, are there female suicide bombers in Lashkar-e-Tayyaba? Headley says, no, I don't know. The prosecutor then asks him, can you name a suicide bomber? It's a slightly strange sequence of questions. He just told you he doesn't know whether they have suicide bombers. So he says, you give me the name of one. Well, the court allows it. That's the way the record speaks today. So the prosecutor says, can you name a suicide bomber? So he says, I cannot name. The prosecutor then asks him, was there a botched up operation in India? Headley says, yes, there was a botched up operation, which I learnt while Zakiur Rahman Lakhvi was talking to Muzammil Bhatt. Later I asked Muzammil and he told me there was a female member of LET who was killed in a police shootout at a Naka, exact place I cannot recall. Now what is he telling you? He's not giving you any name. He's saying there was a botched up operation somewhere in India. Some woman was shot dead. I don't know who she was. I can't even remember the place. Later apparently he says, do you think it was Gujarat? He says, yes, I think it was Gujarat. And then he says, how do you know? Now a witness can only be a witness to something that he is privy to directly. He's seen or heard or something that he's done or has happened in his presence. This is hearsay twice over. He's saying, I overheard Zaki, Rahman, Lakhvi and Muzammil talk, and later Muzammil told me that he knew that something had happened elsewhere. So this cannot be read as evidence under Indian jurisprudence or under any known jurisprudence in any civilized world. Very well. Not satisfied, and this line of questioning continues to be allowed, and this kind of answers continued to be allowed to come on record even though it cannot be read as evidence in India. Another question is posed to him because he still hasn't given the answer that the prosecutor is desirous of. So then he says, I will give you three options: Noor Begum, Ishrat Jahan and Mumtaz. So Headley says, I think it was the second one. I have heard the name Ishrat Jahan. Well, actually by now a lot of people across the globe, particularly in India, have heard the name Ishrat Jahan, thanks to the political parties who seem to want to make a little circus out of a very serious case. Now, what is one to do with this, what has been stated by Headley? It's certainly not evidence. It cannot be read either in this case, and definitely has nothing to do and is totally irrelevant to the criminal case of murder, of quadruple murder, including Ishrat's, which is pending in Gujarat. This piece of paper cannot be read there. Firstly, because you cannot do Kaun Banega Terrorist games in court. This is a serious matter. We are dealing with national security issues. Secondly, the court was simply going to say to you, look, I don't care who she was. You had her in your custody and you killed her. I'm interested in who killed her. who she was, you like her, you dislike her. It's like tomorrow saying, oh, my wife committed adultery, so I killed her, and therefore it's a righteous murder. It isn't. Or saying that, you know, so and so is, according to me, a Maoist, and therefore Salwa Judum has a right to kill. No, it doesn't have a right to kill. And the Supreme Court and every court has said this more times than it should have had to. So this is as far as David Headley goes. However, as soon as this was done, immediately every person of any worth in BJP was on the media saying, see, now we know she's a terrorist. We don't know. We are nowhere closer to knowing. We only know that you are making desperate attempts and still not succeeding in linking her with any terror plot or terror group, because nobody, actually she wasn't linked to any, and so there is no evidence. Secondly, now on cue, after that, Mr. G.K. Pillai decides that it's time for him, and perhaps the David Headley testimony, as useless as it was, collapsed and did not serve the purpose that they had hoped it would. So then other people were called in to step up and step in. So Mr. Pillai did not speak up for the first time. Mr. Pillai actually spoke in November 2011. Thereafter he spoke in 2013 and now in 2016. So for those who are saying, see, Mr. G.K. Pillai has told us something new, let us please remember that he actually speaks periodically on exactly the same thing. But since none of it is worth anything, it slips away and nobody pays any attention, and the court certainly can have nothing to do with all this. So what did he tell us in 2011, 2013 and 2016? Let me come to what he has said in so in 2013, I'll read what he has said. 2013, he says, former Union Home Secretary G.K. Pillai has said he cannot say with certainty that Ishrat Jahan, the Mumbai college girl shot dead by Gujarat police in 2004, was an LET terrorist and would give her the benefit of doubt. So in 2013, he was not sure. He definitely did not say anything while he was the Home Secretary and would have access to all information, including IB information. He does not tell us anything about Ishrat at that time. 2013, he says, I will give her the benefit of doubt because there is nothing. And in 2011, also he says that there is nothing that he knew about Ishrat. Here, the statement he makes in 2011 is, former Home Secretary G.K. Pillai says that the SIT conclusion on Ishrat Jahan's encounter and her links with Lashkar-e-Tayyaba are two separate matters. So he is, till 2011, he is saying what the Indian law and jurisprudence requires him to say here. What does he say now? Now he says, and we are told that these are explosive revelations. So now he says that there was some political meddling, and therefore he says that she was a cover for them, and that the CBI had indulged in leaks. Actually, there is no leak made by the CBI whatsoever. The CBI charge sheet is quietly sitting and nobody is paying any notice to it. And he says that this was a Lashkar-e-Tayyaba operation and the IB had conducted this operation. Now, why he doesn't tell us this, why he tells us this so many years after he's retired, is a question he needs to answer. What to my mind is something even more scandalous. I mean, one can understand he's doing all this for whatever reasons he would best know. But I think he's stooped rather low this time. And since none of this Headley business was making any headway, therefore to say it's an IB operation is not going to prove anything. So what does he decide to do? Something that the BJP has been indulging in ferociously for some years now. He says, Ishrat knew that something was wrong. That's really neither here nor there. An unmarried Muslim girl went with a married person, spent nights with him as husband and wife. She was cover for them. For Mr. Pillai, who till now even I had a very high regard for. I think he's joined the ranks of those political leaders, and particularly those in the BJP, who think that they have a right to pass remarks on women, particularly working women, whether she is she's an unmarried girl with a married man or not. I think many of us and our children, when we are working, this is the nature of work. Now, whether she was staying in the same room or not, what is the need to bring this up? What is the need to bring this into the conversation here, except because nothing that you're saying about Lashkar-e-Tayyaba sticks to Ishrat. So since that Lashkar-e-Tayyaba bogie qua Ishrat does not work, so let's pull down a woman in the tried and tested manner that has always worked and attack that, oh, she's just not a good woman. And you know, if you are not a good woman, then you must be a Lashkar-e-Tayyaba terrorist. And this is the nature of what G.K. Pillai has said. And I think there is no reason for anybody to pay any attention to this. And I think Mr. G.K. Pillai's credibility and work of many years of a bureaucrat, he himself in one stroke has totally and utterly destroyed. And if he wants to be the mouthpiece of the present government, he is welcome to do it. But if he is going to make defamatory comments about my client's daughter, then my client will take whatever legal action she needs to against Mr. Pillai also. Well, you see, what is happening is that charge sheet is sitting there. And a charge sheet cannot sit there forever and ever. And sooner or later, that trial will have to begin. Now, in that, there are not only IPS officers and IB officers who have professed loyalty to people who are in power today and are ruling the country today, but those who are in power are also named. Now, judicial processes who can be unpredictable, and witnesses can state certain things, and there may be a time when accountability may be fixed. Of course, the CBI is making no efforts whatsoever, but I imagine that they thought with the Headley thing, they'll once again change the discourse and say it's a Lashkar matter, so let's just all take some referendum in the country that we will not allow this trial to proceed because it is in our national interest. And I think there is actually, apart from the specificities of this case, which have a direct link to people who are in the topmost political executive of the country today, I think there is also an attempt today to shape a new kind of discourse. And we saw evidence of this actually come out repeatedly from certain quarters, including former editors who think that controlled killings are in the interest of the nation, even if in those controlled killings, I suppose Ishrat Jahan would be what they would describe as collateral damage. Now, it's very fine to use these kind of phrases, but there is a mother, Shamima Kauser, here, and since I'm told that the pain of a mother is understood by those in power, then this Shamima Kauser does not think of her daughter as collateral damage. She thinks of her daughter as a person for whose murder somebody needs to be made to account for. They can keep saying it till the cows come home. Inside the courtroom, every lawyer defending them can say it, every accused can say it. The judge can do nothing but ignore this. The Indian Constitution and the rule and Indian criminal jurisprudence do not permit, under any circumstances, this murder, and can only treat it as a murder. You see, in an encounter case, it's in many ways an open and shut case. They said we killed them. Now, if the investigation has shown that they were taken into custody and shot in cold blood, you don't have to think very hard to figure out who did it. They have said it, we did it. So it's only a matter of time that people can get convicted. Therefore, this constant effort, but I don't think, no matter what kind of majority you come to in Parliament, I don't think the law of this country can be overturned in this manner.